Welcome to LexTalks. Legal Topics Simplified, your companion for exploring the fascinating world of law.
Hmm.
Today, we're diving deep into something super relevant for you
Okay.
as law students in India.
Right.
We're tackling Article 22 of the Indian Constitution,
Right.
the one that safeguards you against being arbitrarily arrested or detained.
It's a big one.
It is a big one.
Yeah, it's one of those cornerstones of Indian law that everyone should understand.
Oh, absolutely.
Not just aspiring lawyers.
Exactly. And we've got a treasure trove of sources to guide us.
Oh, cool.
Excerpts from Wikipedia,
Okay.
a legal blog that specializes in making law accessible,
Nice.
articles on human rights from Australia,
Wow.
guidelines on international human rights, even a student's sharp legal analysis.
That's pretty thorough.
It is.
Yeah.
So get ready to explore historical cases,
Hmm.
how those preventive detention laws in India evolved, and what arbitrary really means in legal terms.
We'll even touch upon a landmark case that set guidelines for how the police should behave during arrests.
Oh, very important.
Yeah.
Okay, let's unpack this, starting with the basics.
Right.
What exactly do we mean by arbitrary arrest and detention?
Yeah, that's a good question.
The Wikipedia source cuts to the chase,
Okay.
saying it's when you're arrested or detained
Yeah.
without any real evidence, no proper legal process, or no legal justification.
So basically no reason at all.
Exactly.
Hmm.
It's a violation.
Think of it this way. The state has immense power, right?
Oh, for sure.
But that power has to be used responsibly.
Yeah.
Article 22 is all about making sure that power isn't abused when it comes to arresting and detaining people. It's a constant tug of war between individual liberty and the state's need to maintain order.
And that's where Article 22 steps in with a whole system of safeguards.
Okay.
It's more than just a few lines in the Constitution. It lays out specific rights for anyone who gets arrested.
Right.
Like you have the right to know why you're being arrested, the right to talk to a lawyer, and the right to be brought before a magistrate within 24 hours. This is straight from the Indian Constitution itself.
So you're covered?
They were.
Those are some serious safeguards. It's all about accountability and transparency.
Mm-hmm.
The state can't just snatch you up without a good reason and without following the rules.
Nope, they can't.
It's about fairness.
But here's where things get really interesting.
Okay.
Article 22 differentiates between two types of detention: punitive and preventative.
Okay.
Punitive is what we usually think of. You're punished after being found guilty.
Right.
But preventative detention,
That's a whole other beast.
it is a whole other beast.
Yeah.
That's about stopping something before it happens.
Right.
The state can detain someone if they believe that person is about to commit a crime, even if there's no concrete evidence yet.
Oh, wow.
This is where that tension between individual freedom and state power gets really intense.
Yeah, I can see that.
So to really grasp this, we need to rewind a bit.
Okay.
The article on preventive detention laws in India gives us this fascinating historical overview.
Lay it on me.
It all began with the Preventive Detention Act of 1950. Back then,
Okay.
the government could detain people they considered threats to national security, public order,
Hmm.
even the supply of essential goods.
Wow. So pretty broad.
It was broad.
Yeah.
Then came the Maintenance of Internal Security Act of 1971, or MISA for short.
MISA, now that rings a bell,
I've heard-
didn't spark a ton of controversy?
It absolutely did.
Yeah, I thought so.
It gave the government a lot of leeway in detaining people,
Right.
and many feared it would be misused.
Yeah, that makes sense.
The article mentions several cases that highlight these concerns,
Oh, really?
like A.K. Gopalan versus State of Madras in 1950.
Okay.
The Supreme Court upheld the Preventive Detention Act in that case, right?
They did. But even while upholding it, they expressed some serious reservations about the whole concept of preventive detention. It's a tricky legal area.
It is.
Yeah.
And MISA was eventually repealed, wasn't it?
Yes, in 1978.
Okay.
But that didn't mean the idea of preventive detention vanished. It morphed into other forms, like the National Security Act of 1982, which is still in effect today.
So it's like a legal game of whack-a-mole.
Yeah, kind of.
But seriously, this history shows how the government has wrestled with this whole idea of preventive detention.
It's a tough one for sure.
It is.
Yeah,
And it highlights why the safeguards in Article 22 are so critical.
absolutely. Even when someone is preventively detained, they still have certain basic rights.
Exactly. And speaking of safeguards, zoom in on one of those,
Oh,
the Advisory Board.
right.
This board has a crucial role in reviewing detention cases.
Hmm.
They weigh in on whether there are sufficient grounds for keeping someone detained.
Okay.
It's like having a second set of eyes on the situation, making sure the government isn't overstepping.
And the composition of the board and the timelines for their review are important too. That same article we mentioned earlier explains how the 44th Amendment to the Constitution made some significant changes to the advisory board process.
Before the amendment, the rule was no one could be detained for more than 3 months without the advisory board giving their opinion.
Oh, wow.
The 44th Amendment tried to shorten that to 2 months, which is a big deal. It also wanted to change how the board was formed, proposing that the Chief Justice of the relevant high court would have a say in who sits on it.
Interesting.
And there's more. The amendment wanted to take away Parliament's power to make laws that allowed detention beyond 3 months without the advisory board's say-so.
That's a pretty big shift in power.
It is. It's a clear sign of how the legal landscape is always evolving and how amendments can reshape how we interpret and apply fundamental rights.
It reminds us that the law isn't set in stone.
Right.
It's constantly adapting to societal changes and how we interpret those changes.
Now let's tackle the big, sometimes confusing word, arbitrary. What exactly makes an arrest or detention arbitrary? It's not always black and white, is it?
You're spot on. It can be really nuanced. This source from the Australian Human Rights Commission helps us unpack this. They discuss a 2007 case, Shams et al. Australia,
Sure.
which dealt with mandatory detention and whether it aligns with Article 9 of the International Covenant on Civil and Political Rights, ICCPR.
The ICCPR.
Yeah.
Now that's a big one in international law, right?
It's a cornerstone of international human rights law.
Okay.
It lays out fundamental human rights that countries are supposed to uphold, including the right to be free from arbitrary detention. In the Shams case, the individuals were detained for years without a real chance of having their detention reviewed by a court.
Wow.
The UN Human Rights Committee decided this detention was arbitrary.
So even if a country's own laws say detention is okay, it could still be considered arbitrary under international standards.
Yeah.
That's a pretty powerful point.
Right. It's not just about what a country's laws say, it's also about how they are applied in real life.
And you know what else is interesting?
What's that?
These guidelines on international human rights and drug policy we have, they offer valuable insights.
Okay.
They lay out 5 categories of arbitrary detention based on international standards.
So they break it down.
They do. These categories cover situations where there's simply no legal basis for detention,
Right.
where detention is used to punish someone for exercising their basic rights, like freedom of expression,
Oh, I see.
and situations where due process rights are violated.
So this issue goes beyond just one country's laws. It has global implications.
Exactly. It crosses borders and touches on universal principles of human rights.
It's about human dignity everywhere.
And that brings us to a landmark case in India, DK Basu v. State of West Bengal.
Okay.
This case was crucial in establishing guidelines to prevent violence while in custody and ensure that the rights of people who are arrested are protected.
It was a big deal because there weren't specific laws to deal with police power, you know? So this case helped align Indian law with those international standards, like the ICCPR we mentioned.
And it led to 11 incredibly important guidelines, which we have right here in front of us, outlined in this student's legal analysis.
11.
11 guidelines.
Wow.
It's important to note that these guidelines don't replace the safeguards that are already in the Constitution and other laws.
They build upon them.
Exactly.
It's like adding extra layers of protection.
Exactly. The DK Basu guidelines are all about making those safeguards even stronger and offering more specific ways to prevent arbitrary arrest and detention. They cover practical things like making sure police officers have clear identification,
Right.
informing family or friends when someone is arrested,
Okay.
and conducting regular medical checkups for anyone in custody.
Those aren't just bureaucratic details.
Oh, no.
These measures are in place to prevent abuse and ensure that the basic rights of anyone who's been detained are respected.
Absolutely. And one guideline that really stands out to me is the one about informing the arrestee's family or a friend. It's not just a courtesy, it's a vital safeguard.
Yeah.
It means the person who's been arrested isn't held incommunicado,
Right.
completely cut off from the outside world.
Another key aspect is the guideline about medical examinations. Requiring checkups every 48 hours helps protect the arrestee's physical well-being. It provides some protection against custodial violence, which sadly can be a reality in some situations.
And it's not just about physical well-being. The right to legal counsel is paramount, wouldn't you say?
Absolutely. Having access to a lawyer is crucial throughout the entire process, especially when it comes to resisting further detention and applying for bail.
Mhm.
It's a cornerstone of a fair and just legal system.
And to add to that, Article 39 of the Constitution, which one of our sources highlights, specifically addresses the right to free legal aid. This ensures that everyone, regardless of their financial situation, can have legal representation. It levels the playing field and ensures access to justice isn't limited to those who can afford it.
Precisely. It underscores the principle that everyone, rich or poor, deserves a fair chance in the legal system.
And there's this really fascinating case mentioned in one of the sources, A.S. Muhammad Rafi v. State of Tamil Nadu, that really highlights the universal right to legal defense.
Okay.
In this case, a bar association tried to prevent its members from defending certain policemen.
Wow.
The court ruled against this resolution, emphasizing that everyone, regardless of the accusations against them, deserves legal representation.
That case serves as a powerful reminder that the right to a fair trial is paramount, and that includes having a lawyer by your side to defend you. It applies even to those accused of the most serious offenses.
It really drives home the importance of these safeguards in protecting individual rights within the framework of the law.
Mm-hmm.
It's like a safety net, ensuring that the system doesn't trample on individual rights even when pursuing justice.
It's a reminder that our legal system is built on the idea that everyone deserves a chance to defend themselves and that the power of the state must be balanced with the rights of the individual.
So if we zoom out and look at the bigger picture, Article 22, with all its clauses and amendments, is a vital shield against arbitrary arrest and detention. It's designed to protect individual liberty even when the state is exercising its authority.
And understanding those safeguards is critical, especially when you consider the history of preventive detention laws in India and how they've been used and sometimes misused over the years. It's a constant balancing act, and knowing your rights is the first step in protecting them.
This deep dive has been incredibly insightful. It's not just theoretical knowledge, it's about empowering people to understand their rights. But it also raises a question in my mind: how do these safeguards in India compare to those in other countries?
That's a really interesting question. The source on arbitrary detention makes it clear that this isn't just an Indian issue. The concept of arbitrary detention is recognized internationally.
So there are global standards for what constitutes arbitrary detention.
Absolutely. Those standards are laid out in international human rights treaties like that ICCPR we discussed earlier. It's about setting a baseline for how governments should treat individuals no matter where they are in the world.
That makes sense. But do these international standards have any real teeth? Do they actually change things on the ground?
That's a complex issue. There's always room for improvement when it comes to enforcing human rights, both domestically and internationally. But I think the very fact that there are international standards and bodies like the UN Human Rights Committee to monitor compliance shows that there's a growing global awareness of how important it is to protect individuals from arbitrary arrest and detention.
It's fascinating to see how these legal ideas and principles go beyond national borders. They connect to a broader conversation about human rights on a global scale.
It highlights the interconnectedness of our world and the shared responsibility we have to uphold human rights everywhere.
It's like we've peeled back all these layers of Article 22,
Yeah,
starting with like what it actually means.
the basics.
Yeah, the basics. And then looking back in time at these big cases.
The history.
Yeah, exactly. And then how these laws changed.
And how it all fits into the global picture.
Exactly.
Yeah.
It's been really eye-opening.
It's fascinating how the law is always in motion, isn't it?
It is. It's always evolving.
Like a living thing.
And for all of you law students listening,
Yeah.
I hope this deep dive has given you a solid grasp of Article 22.
The essentials.
Yes, and how crucial it is in the Indian legal system.
It's not just about passing exams or something.
No, it's bigger than that.
It's about understanding how our rights are actually protected in the real world.
Exactly. It's about becoming the kind of lawyers who champion justice
Right.
and stand up for those who need it most.
Absolutely.
So as we wrap up this deep dive, I want to leave you with something to think about.
Okay, sure.
How can we, as a society, make sure that balance between individual liberty and state power is always maintained?
That's the big question, isn't it?
Especially in a world, where things are changing so fast.
Right.
With new threats and all,
Mm.
how do we keep that balance?
It's a challenge, that's for sure. I think it starts with conversations like this one,
Yeah.
understanding how complex the law really is.
Being open to different perspectives.
Exactly, and advocating for what's right.
Well said. Thank you for listening to LexTalks.
It's been a pleasure.
Follow, subscribe, and stay notified to never miss an episode.